SJC-12830, Commonwealth v. Amador, Medina.
Lazar, good morning.
Good morning, Ellen Lazar for the Commonwealth. This case is before the court on further appellate review of a suppression order issued by the Worcester Superior Court. This court should reverse the order because the motion judge mistakenly concluded that the defendant was in custody when he spoke to the police, necessitating Miranda warnings, and that the defendant's statements were involuntary. A defendant who claims that he was subjected to custodial interrogation has the burden of proving custody, which is a formal arrest or a restraint on movement of a degree associated with formal arrest. The defendant did not prove that he was in custody in this case, and Judge Frison erred in concluding otherwise.
Can I ask one question that seemed odd to me? So a search warrant issues. Do we have cases where a defendant knows a search warrant has been issued, he's being questioned for, at this point, 5 or 6 hours, that's not custody? It just seems like there's a lot going on. I would think that the fact that a search warrant issues for your apartment seems to be an important factor. Any cases, again, where a search warrant is issued, but you're not, while you're being questioned and there's not custody?
I did not find any cases with that set of facts, and of course, there's two separate, there's questioning that occurs at the apartment, and then there's questioning that occurs at the station.
Right.
And there's a break of a couple of hours in between.
Right.
And
but
it's
we know there's probable cause to search, right? I just found that a difficult fact to get around if I'm the Commonwealth, but I'm sure there's a reason, but educate me.
Well, Your Honor, I would say in response to that, that if the court were to find at that point, so it's only when they leave the apartment and go to the police station that he's told that the police are going to obtain a search warrant for the apartment. So if the court were to find that custody began at that time, then I would ask the court to reverse so much of the suppression order as suppresses evidence that occurred before that time, as to statements made and observations made prior to that.
Remind me though, but when the police first come in and they inquire about the bones, and so, not only does he invite them in and he shows them.
Yes.
He shows them where they are, right?
Yes, and so you're...
And even says how he got them.
Right, and so as soon as Officer Gustas knocks on the door, says, "We received a call that you have remains here," he invites him in. He's very expansive. He voluntarily shows him, "Yes, I have bones. Here's where they are. Here's what I use them for. I have them here," and tells him all about his religion. He's walking him through the apartment. The whole conversation is very relaxed and cordial. There's certainly no restraint on the defendant's movement. There's no arrest, there's no threat, there's no aggressive tone.
So that's interesting, because your answer to this question forms, the question is really important in this case as well. You didn't just go through the groom factors. You mentioned other things that we should consider as well. So it doesn't seem like this is an issue of whether it's Connecticut law or Massachusetts law. This is an issue of we're dealing with federal law and what constitutes custody, right?
Yes.
And so should the judges, when they're applying a doctrinal framework to this, be limited to the 4 Groom-Bryant factors, or should there be a wider range of factors like the ones that you were just touching on?
Well, I believe that if you look at Massachusetts cases assessing whether someone is in custody, that really what they are applying is a totality of the circumstances test, which is applying the federal standard, which is formal arrest or a restraint on movement akin to formal arrest, and that It is informed by the groom factors, but certainly not limited to those factors, that it is a totality of the circumstances test, and in groom itself, the court uses that language, that it's examining all of the circumstances. And if you even look at the 4 factors, one of them, the nature of the interrogation, I think is broad enough that it really covers everything. So even if you look at the appeals court decision in this case, even though they say we'll apply the 4 factors listed in groom, they talk about, for instance, the length of time that he was with the police. Well, there's nothing in groom that specifically sets forth that that's one of the factors that should be considered, but it's clear from all of the cases that the courts examine the totality of the circumstances in making a determination of whether this federal standard has been met.
Now, the Judge Friesen says that all of it is suppressed.
Yes,
The appeals court says none of it is suppressed.
yes.
Why is there not some middle ground here? I mean, I understand when Officer Gustus comes in, it may not be that he may not have been obliged to give the Miranda at that time, but then we have Sergeant Labbe entering, and he didn't knock and seek permission to enter. He just walked in the door, didn't he?
The judge didn't make a finding on that, and the evidence, I think, was a little bit ambiguous on that question. He did not testify at the hearing. He was only in the apartment for 5 to 10 minutes, and there wasn't any evidence really about what Sergeant Labbe did or didn't do. Other than he came in, Officer Gustus updated him on what he saw, and then Sergeant Labbe called the detective unit, and Detective Frykowski came out, and he was the person who made more of the observations and did testify at the suppression hearing, and that's what led to the obtaining the search warrant and bringing the defendant back to the station to
So
get his
when Detective Rakowski and Rakowski testified,
Yes.
I don't recall, I only glanced at his testimony, I don't recall him knocking on the door and asking permission to enter. I believe they just entered, didn't they?
No, he testified that he radioed Officer Gustus, where am I going to get into this place? And that Officer Gustus said, come to the back door, so that Detective Frykowski went to the back door, and when he went to the back door, the door was open, and that the officer and the defendant were sort of just inside the door in the kitchen, and so that from the doorway, he introduced himself to Mr. Medina. And I don't know if he literally, I think he testified that he asked if he could come in, or the defendant said he could come in, but there was some communication, the thrust of which was, he didn't just walk in the door.
Do you have any finding on that? I had a memory that he did not seek permission before he entered.
The judge did not make a finding on that one way or another. It was in the testimony at the hearing, but she did not make a finding one way or another.
Along those lines, I couldn't help but thinking the same thing that Chief Justice was thinking, that, at some point there might be custody here. But if we're looking at issues like that and some of the other issues, what do we do as far as fact-finding with the statement in the judge's decision, any facts relayed at the hearing but not recited in the decision were not credited by the court? What do we do with that if we are trying to find where that line is, if in fact there was a point that eventually evolved into custody?
Right. It is obviously somewhat problematic, but I think the vast majority of the facts were uncontested. I think both parties agreed to the way that things occurred, and there may be a few instances where there were disputes where the court could not make a finding or an assumption one way or another. But for instance, I think there's one instance in the Commonwealth's brief where I noted only the conditions back at the police station regarding the room in which the defendant was questioned, that the door was unlocked and he was given a meal and there was a bathroom, that both parties agreed that this was the case, and the judge made no findings regarding the conditions of that room. But I believe that as to the vast majority of the facts to which the officers testified at the hearing, there was no dispute, and so I believe that the court could supplement the judge's findings with those facts. But in the few areas where there was any dispute as to those facts, that the court would not be able to do that.
Now, the judge found that she did not credit the testimony that said that they did not recognize that there was a crime.
Right.
Don't we have to honor the judge's finding with regard to that?
Except that she also contradicts herself, and because she also found at the beginning that Officer Gustus was unaware of crimes regarding the disposal of human remains or possession of human remains.
How often do those cases come up?
I don't know, and I suspect she didn't know, and there was no evidence about it. I think what's really important is if you look at her decision.
How often do you take pictures of a cemetery with the bones hanging out? Might be a little suspicious, don't you think?
I think what's really important to focus on is that she literally gave one reason why she believed that the defendant was in custody. From the moment that this officer walked in the door, she believed that he was in custody because she believed that the officer should have known that they were investigating a crime, period. She believed once the officers heard that there was a claim that the defendant had human remains, they should have known that they should have been suspicious.
Why would they have gone to the apartment in the first place if they'd heard that and didn't think it was a crime?
I'm sorry, I didn't
Why
know.
would they have gone there in the first place? Why would they have gone to the apartment in the first place if they didn't think that there was something wrong with him having the bones?
Well, they got a call from someone that this person might have human remains, and so they went there to
Because it's a problem
investigate
to have
that.
human remains, isn't it?
Possibly. And so they didn't know, are there human remains? Are they new? Are they old? Is it someone who was just killed? Are they bones? Are they human bones? I mean, they really didn't know. They got a call and they went to check it out. But it's clear under the law that what an officer thinks subjectively, what an officer believes, whether the officer believed a crime was committed, whether the officer believed the defendant had committed it, is not relevant to the determination of whether a defendant was in custody.
Isn't that Commonwealth versus Morse making that point as clear as can be, that it's an objective from the perspective of the person being inquired of?
Right, and so that is where the Commonwealth's claims that the judge erred in finding that the defendant was in custody, because she believed that as soon as the officers heard a claim that there was remains, they should have suspected that there was a crime, and that meant the defendant was in custody, period. If you read through all of her findings and rulings, that is the only reason she gives for finding that the defendant was in custody, despite finding that the whole interaction was so cordial and conversational, and he was so expansive and unprompted. He takes out his cell phone and he shows them the pictures, and there's no threat, and it's not aggressive, and they have this conversation, and he's explaining his religion. Despite all of that, the only reason she finds that he was in custody is because she says they should have known that they should have suspected a crime was committed, and because they acknowledged during their testimony at the suppression hearing that if he had asked to leave, they probably would not have let
Well, can I
him
ask you
go.
a question? Would this have been a crime in Connecticut? He was not charged with a crime in Connecticut, I take it.
He was never charged with a crime in Connecticut, and although the judge lists a couple of crimes that she says might have been committed, even at the suppression hearing, the officer said, I wasn't planning to arrest him for anything. Once we found out that these bones may have been taken in Worcester, Massachusetts, I can't arrest him for a crime he might have committed in Massachusetts. I was planning to bring him home.
I guess the point is that having them in Connecticut wasn't a crime that they were going to charge him with.
No, and so that's where the Commonwealth's position is that she erred in finding custody because she based it only on believing that they should have suspected a crime was committed, and clearly that's not the test for custody.
Let's assume she was wrong for the moment, and that we need to identify when, if at all, there was custody. Record Appendix 83 is Detective Rakowski. After he had seen the Hope Cemetery photograph, and he called Worcester and learned that they had a break-in at that time, and he testified, I explained to him that I was going to do that by way of a search warrant because we believe these remains came from Worcester and that I would need to recover them because they are remains of someone's family. I explained to him that I was going to do that by way of a search warrant. And then I would ask if you come back to the police department with me and give you an actual statement on that so that I didn't misquote anything he told me. Why would that not? At that point, he was getting a search warrant, so there must be evidence of a crime. He had already observed the photograph of the Hope Cemetery and learned that there was a break-in, and now there were 4 officers with him in the apartment. Why would that not be a time in which it's appropriate to find that that was custodial?
Well, because first there were 3 officers, not 4, because Sergeant Labby had left.
He left, okay, so there were 4 who showed up, but 3 who stayed.
Right.
Okay, so,
Because I would say that despite that, so perhaps now one factor is that the defendant could interpret that to mean that the police now suspect him of a crime. But nothing other than that has changed in terms of the tenor of the interaction between the police and the defendant. And if the standard is whether there's a restraint on movement akin to that of formal arrest, there's still been no restraint on his movement. There's still nothing in the no change in the tenor. I liken this to, for example,
There
Commonwealth
is a
versus
restraint, but,
Bryant.
I mean, when there's a search warrant, there's a restraint on his movement. He's not going to be able to move around his apartment when they're searching the apartment, right? He's been informed there's going to be a search warrant.
Well, they ask him, would you be willing to come to the station with us and give a statement? He says yes. They say, do you want to drive yourself? And he says, I don't have a car. Can you drive me? So they say, okay. He agrees voluntarily to go. They don't tell him he has to go. They certainly don't handcuff him.
By the way, is this again, I mean, at this point, they know everything they need to know, right? You're fighting something that's kind of meaningless at this stage, aren't you? I
Well,
mean,
that's
you've
what-
got all the information you need. You really want us to conclude that when you've asked for a search warrant and you ask him to come to the station and you're going to get him, you know, how many hours are we into this at this point? That's not custody, really?
Well, the judge found at that point when they leave the apartment to go to the station, it's been a total of 2.5 hours.
So you've been questioned for 2.5 hours. They're getting a search warrant for your apartment. They found bones. They've got pictures of a cemetery that's been invaded. You're not in custody then? God,
No, not under the standard as it's been expressed by the Supreme Court and applied by this court. I mean, there's been no restraint on his movement at all. And the fact that they've told him, listen, it looks like these bones were taken from a place where you shouldn't have them. We need to recover them and get them back to these families. Is not akin to restraint on his movement associated with formal arrest.
So the purpose of going back to the station was to get his statements to put into the search warrant, correct? They said, we want you to come back to the station to give a statement, and the purpose of the statement was to author the search warrant, correct? It was a statement for the search warrant, right?
Right. I don't believe so. I think at the same time as all of this was happening, Detective Rykowski had radioed other detectives to start.
I should ask you a better question. What did they tell him was the reason to go back to the police station?
That they wanted to, Detective Rykowski told the defendant, you've told me a lot of things about your religion and why you have these bones and the purposes of having them, and I want to make sure that I get all of that information accurately. So can we go back to the station and we can write it down to make sure that everything you told me is accurate?
But I
And
thought it was, we want a formal statement from you, right? They told him they want a formal statement. Or does that not come up until hours 11 or 10 or whatever we are later?
I don't know if they use the word formal, if they use the words formal statement, but I know that the reason that that he gave him was that he wanted to make sure that he accurately represented in the statement everything that the defendant had told him about his religion.
They'd already been in touch with the Worcester Police at that point, hadn't they?
Yes.
Before they got the search warrant or after they got the search warrant?
Before they got the search warrant, after the defendant,
The Worcester thought there was a real problem there, that they wanted him.
so when they were still at the apartment, once the defendant showed them the photograph that said Hope Cemetery,
Yeah.
and confirmed that the cemetery was in Worcester, Massachusetts, they called Worcester. Worcester confirmed that they had had a break-in at a cemetery.
And did the defendant know that the police had called Worcester?
Detective Rykowski said that he told him at the apartment, we spoke to Worcester, and we think that he told him at the apartment that they confirmed with Worcester Police that there had been a break-in at a cemetery there. But then later in the evening, after the statement was completed, the defendant again asked if they had spoken to Worcester Police, and they said they did, and it was at that point that the defendant declined to sign the statement, although he confirmed that the contents of it were accurate.
Well, it seems like certainly at the apartment, at some point, objectively, from the defendant's perspective, he realizes that he's the person that they're looking at for a crime. But, and so I don't know how that one factor plays with however many factors we're looking at in the totality of the circumstances. But once they get to the police department, when you start to take into account the location of the interrogation and whether or not the police were really going to let him leave at that point, along with the being the target that they're looking for as it relates to a crime, even if the nature of the interrogation was not really aggressive. I mean, once they get to the police station, does it seem like it turns into custody there?
I think that obviously a police station is more of a police-dominated atmosphere than in someone's own home. But I think that looking at the circumstances of this particular interaction, that it was not so much so that it became custodial in these particular circumstances. Again, he was given the opportunity or offered to drive himself. He was asked to go. He voluntarily agreed to go. They told him that they would give him a ride home. In the end, it didn't end up that way because the Worcester Police asked them to arrest him on fugitive from justice warrant after his statement was completed. But they gave him dinner. They just had the exact same conversation with him that they had already had at the apartment. Again, the tenor was not aggressive. It was still a cordial conversation. And so obviously the circumstances had changed to some degree. I don't think it was to a degree that made it custodial. But again, I would ask that if the court found that it became custodial at that point, that the suppression order would be reversed to the extent that anything after that point might be suppressed, but not the statements and observations made at the apartment. And also, I would ask the court to reverse the judge's finding of involuntariness, which appears to be based only upon the absence of Miranda warnings. She made not one other finding that suggested that the defendant's will was overborne. She simply said this was custodial, Miranda warnings weren't given, and this was involuntary, and suppressed everything.
Okay, before you sit down, let me just make sure I understand. I gather from what you said earlier that the groom factors are not meant to be exclusive, that the test is totality of the circumstances, and the groom factors are simply one analytical means to examine the totality. Is that your take on it?
Yes, it is.
Okay, thank you.
Thank you.
Mr. Osborne.
Morning, Your Honors. My name is David Osborne. I represent the the appellee in this case, Amador Medina. The good news here is that we're all in agreement, apparently, that it is a totality of the circumstances test that determines whether Mr. Medina was in custody. The appeals court does not appear to have had that view. It cites, strictly speaking, the 4 groom factors. It sets them out as 4 headings, describes evidence under those factors, and omits a great deal of the evidence that we cited in our brief. We laid it out very carefully, as we did in the brief to this court, all the evidence that favored a finding of custody, and almost all of it was ignored by the appeals court. Duration was mentioned, and that was actually a factor that troubled the appeals court. But that, of course, comes broadly under the notion that a factor regarding the nature of the interrogation. So the appeals court appears to have been strictly construing groom as limiting its review to 4 factors. I think the important thing for this court today is that it can clarify groom. When you read groom, as I've done many times,
But can I ask
I see nothing in there.
Before you get to that, though, it's Connecticut, and I'm confused by that point, too. I mean, I understand we're both looking at a federal custody standard, but should we be looking at through the prism of Connecticut or through the prism of Massachusetts case law?
Your Honor, I think the answer is, if you decide that groom must be read to consistent with federal law, with the United States Supreme Court law, which is
that's
totality of
clear.
circumstances, then you don't need to reach that question.
Well, I guess that's, I mean, and that may be right, but I'm just trying to understand it.
Because the important thing
So
is...
does it not matter that this has happened in Connecticut?
Well, I think
what
the
we're
only,
doing-
if it doesn't matter as long as we're all in agreement, and I believe we are, that the correct standard of review is totality of the circumstances. It's not the factors that Connecticut chooses to highlight. They have 10 factors. There's some overlap with the groom factors, which are limited to 4. The important distinction is that Connecticut, and by my reading, is consistent with the United States Supreme Court law, which is the totality of the circumstances. The problem with groom isn't that the court highlights a different set of factors or a more limited set of factors, maybe broader, maybe narrower, but more limited. The important distinction is that there's nothing in groom that clarifies that it is a non-exclusive list of factors. Connecticut does that. So my only concern with regard to Connecticut is, the difference that I see is that Connecticut is consistent with the United States Supreme Court law. If you conclude that groom is not consistent with the United States Supreme Court law, I think that begs some action by this court to bring it into conformity. I'm not arguing that it is inconsistent. I'm simply raising my concern that the appeals court, which had this issue before, because we raised this as a preliminary issue in our brief very extensively. We presented this concern about groom and asked the court to apply a totality of the circumstances test. There's no mention of that in its opinion. It just proceeds to cite the 4 groom factors and by my reading of it, limits its review of the considerations.
Counsel, can we, putting that aside for just a moment, as when I looked at the groom factors and I looked at the Connecticut factors, it seemed to me that our groom factors are very broad in some ways and could actually encompass the Connecticut factors.
To some degree, that's correct, Your Honor.
I mean, I agree there's a totality issue.
Yeah, the problem is, of course, once you start suggesting that there's a limited number of factors, you are automatically not considering all the circumstances. It's a limitation on it. There was a case that we cited, a Utah Supreme Court case, which a very similar issue came up. And this is not a pro-defendant or pro-prosecutor argument. It was actually the prosecution in that case that said, you should just junk the 4 factors that this court applies. It has a similar, not identical, but a similar list of factors. You should just junk them because it's not consistent with United States Supreme Court law. And the appeals court, the Supreme Court in Utah did not actually decide to junk those factors, but it said, gave a very strong warning that you have to, these are only helpful suggestions, that you cannot ignore other circumstances. And so, and that just by suggesting that there's 4 factors, you can misread what the test is. You can read it very narrowly, even if the factors are broad. You can start to ignore certain evidence, which is what I think the appeals court did in this case.
Can I?
So-
But
Go ahead, please.
it doesn't, I mean, no one loves the appeals court more than me, but I don't.
I do.
I don't think it matters, right? I mean, really, we should be focused right on the trial court's factual findings.
That's right.
Yeah.
That's right.
So what and that's what I'm worried about here.
I understand.
What do we, say we're all in agreement that groom is not exclusive, it's a totality of the circumstances test. We've got limited fact findings by the
Yeah,
trial judge
I have
here.
an explanation for that, Your Honor. I hope it's helpful, because I've struggled with that as well. And by the way, I am not here to defend, in all respects, the reasoning of the motion judge. I think there are some issues with it, and I think the Commonwealth has flagged some of them. But of course, your jobs are to take the facts as we have them in the record, and to apply what we all understand to be constitutional principles and make sure that we come to the right conclusion. What the judge said in her order was, she had this odd statement that if she didn't recite a fact in her factual findings, then she did not credit it. But then she goes on to rely on some facts that she did not cite in her factual findings. So I think there's an ambiguity there. And what we asked the appeals court to do was to, in light of that ambiguity, I mean, one option would be to remand it for clarification of what factual findings should be adopted, but I don't think it's necessary to do that. Most of the facts in this case, as the Commonwealth has pointed out, are not disputed. There's a few.
But I'm just taking you at your word for a second. We don't need to do it, but the first part of this is clearly quite voluntary. And all the damaging information comes in. You know, your client is extremely forthcoming, and you don't need to coerce him because he's just giving out all this information on his own.
Yeah.
So don't we have
I think you're right, Your Honor.
non-custodial conversation until at least they ask for the search warrant?
It happens, I think it happens earlier, though. I understand, and I can, from the tenor of the conversation, I sense that there may be some growing agreement that certainly by the time Detective Rykowski is finished with Mr. Medina, there's an objective, by an objective standard, there's custody. One of the facts that the appeals court did not recognize at all was the search warrant, which I think everyone here is properly focused on as a major event, which really changed the dynamic. So the question isn't so much where did custody begin? It's a spectrum, right? Custody, obviously when Officer Gustis knocks on the door, Mr. Medina is not in custody. By the end, he's arrested, he's in custody. I think we can all agree, or I would urge you to agree, that Mr. Medina is in custody by the time Detective Rykowski comes along. The harder question, I admit, is did custody begin before that? And I would argue that it did. And not just because of all the factors that the Commonwealth cites and that we cite in our brief. You can read those and you can come to your own decision about that, but there's something I want to focus the court on, which I mentioned in my brief, but I don't really emphasize it strongly enough, and I think it's important here. It's somewhat novel. You don't usually see these situations. I have not come across any in any of the cases that I've read. But one thing that we need to keep in mind about what happened during these 8 hours is that when they started off, Mr. Medina showed human remains to Officer Gustis. And as soon as that happens, that changes the whole environment when you think about it. Mr. Medina is now having a conversation with Officer Gustis and then Sergeant LeBay and then 2 police detectives. while he is standing in an apartment filled with evidence of a crime. And by the way, this is an important thing to remember as well. The officers and the detectives who came there, they actually did know that there was a crime. They say it in the, they provide the evidence for the information for the affidavit that supported the search warrant application. It says right here that they believe there's a Connecticut law that's been violated, larceny by possession. That's a Connecticut offense. That's how they got the search warrant. They formed the belief that there was a crime. And the reason that they believe there was a crime.
Connecticut crime.
A Connecticut crime, that's correct.
And it's larceny by possession, basically possession of stolen
Yeah,
property?
paragraph 7, right. That's a crime of larceny by possession. They're clearly talking about Mr. Medina. They have no other person. The basis for that is that Mr. Medina is in an apartment. He possesses human remains, which Officer Gustus said, he testified at the hearing, it's not legal to have human remains. So
Yeah, but, hadn't there been something with him before this? I mean, hadn't they charged, hadn't he been involved with something where there was no, there were no crimes charged against him? But it had to do with bones and human remains and so forth.
there was some,
And he
there
got-
was some
and he- and
testimony
so-
about that.
So he didn't.
There
he
was,
didn't-
yes, and
So he wouldn't have had a reason to think that this was a crime if he didn't have it the last time
it
around.
wasn't clear, Your Honor. It was introduced as, I know what you're talking about. It was introduced.
To me, that was what it sort of explained why he was so forthcoming. I mean, if you've
Yeah,
been
it
around
was,
the block
well,
or
it was,
whatever
it was
before, it's not a
regarding
crime.
the voluntariness of his statement. I think that was the purpose of it. I can't, and by the way, that's a particular quality of Mr. Medina's. The standard here isn't what was Mr. Medina thinking any more than it was what were the police officers thinking. The question here is what would a reasonable person have thought in these circumstances?
But see, that's not the be-all, end-all. As you appropriately point out, we're looking at totality, right?
Right.
So the police could be investigating a murder case, and you could have non-custody
Sure.
in one's house.
Absolutely.
Right?
That's correct.
And then the suspect would know, certainly murder
there's-
is illegal.
That's correct, Your Honor. But the difference here between the cases that you see where there's a murder investigation and a suspect is brought in and questioned is different from this case because here there can be no denial that there is surrounding everybody, the police, the occupant of the apartment, all the evidence of the crime is right there. It's not as though the police are just having this sort of isolated conversation. There's this crime that happened, and we just wanted to find out, what you know about it. That could be a murder investigation where you're interviewing a suspect, and it's not custodial. But what changes, I think, this case is that maybe not Mr. Medina. I can't explain why Mr. Medina opened the door, had these conversations, showed these pictures on his phone. But I can tell you that a reasonable person would not have believed that this thing was just going to end by him saying, you can leave now, officers. I'd like to get back to my religious rituals. That was not going to be the ending of this. Not by a reasonable person standard. Maybe by Mr. Medina's standard, but not by a reasonable person standard. And that's what the police have to consider when they're deciding at what point to Mirandize a person. They don't know what's going on in Mr. Medina's brain, and that's not the test. That's not the question. The question is, what would a reasonable person have thought? And when the police are interviewing a suspect and they have all the evidence of the crime in front of them, a reasonable person would not have felt like I can just walk away.
Right, so they need to know when they have to give Miranda warnings.
Correct, and that's
So,
why it's an
I think
objective test.
in a way, what you're saying is that, sure, it's the totality of the circumstances. Sure, we're not tied to the 4 groom factors rigidly, but that in this circumstance, the factor of he is, objectively speaking, the target of a crime that's clear as can be while he's in the house is so overpowering that when you look at the totality of the circumstances, that sort of drives the point of custody.
That's exactly right, Your Honor. If this had not happened in the presence of all these human remains, I might feel differently. I might think something more would have would have been required to change the dynamic, the search warrant, certainly.
Okay, but that assumes that the possession of human remains is always a crime.
Well, Officer Gustis thought it was. He did testify to that, which is why the motion judge did not credit the police officer's claims that they didn't believe it was a crime, because he actually did admit, I knew it wasn't legal. They didn't know exactly what crime to label it as, and there was a lot of dancing in the testimony. When you read it, it's clear they're trying to avoid
What is the
using the
picture
words.
of Hope Cemetery? What does the picture reveal? I haven't looked at the picture.
My understanding of the picture, Your Honor, is that it doesn't reveal
Doesn't have an
Hope
open,
Cemetery, but
does it have an open grave in it?
it shows some like a crypt that's been open, and Mr. Medina said that it was in Worcester. That's all he said. And at that point, they called the Worcester police, and they discovered that there's been a robbery at a particular cemetery. My understanding is that's how it came about.
So when do you say custody began?
So I think it began, this is what trial counsel argued in his motion papers. I say that it began very shortly after Officer Gustis arrived, because as soon as Officer Gustis sees these human remains, he knows there's been a crime. And a reasonable person in Mr. Medina's shoes also would have known that Officer Gustis knows that there's a crime. Officer Gustis doesn't believe that these human remains are legal, and his possession of them are not legal. And of course, a reasonable person in Mr. Medina's shoes with these in possession knows how he got them, right? So there's no doubt that everybody knows what's going on here. It's not like asking a suspect to come into the police station, have a nice, cordial, friendly conversation, and there's no confrontation with the evidence. In fact, there are cases, Your Honors, where suppression, when custody is found, when, for instance, the police present some evidence to a suspect. They're having a nice, friendly, cordial conversation.
Even though, I mean, they may think he's just crazy, right? I mean, he's saying they're human bones, but, and you know, there's a lot of weird, there's a lot of strangeness going on.
Officer Gustis
Until they see the picture, do they really have a sense that, I mean,
well, some of them are skulls, so we do know that they're human bones. Officer Gustis said, I believed they were human bones. I wasn't sure, but I
he saw the
believed.
skulls?
There were some
I thought the skulls were somewhere, the skulls weren't on the porch, were they?
I believe that's right.
So, I mean.
But they were visible. They were visible. And Officer Gustis said, I wasn't sure, but they looked like human bones to me. And Mr. Medina at first denied it, according to Officer Gustis. He at first said, they're just bones, they're not human bones, or something to that effect. But then at some other point, he confirms that they're human bones because he's explaining the significance of the bones to his religious rituals. So Officer Gustis learns very quickly that these bones should not be here. And that's why they told a magistrate in Connecticut that they believed he had committed a crime in Connecticut, larceny by possession. It's the same thing as...
But larceny by possession, as best I can tell, is basically possession of stolen property.
Yeah, I think it's the equivalent in Massachusetts.
But that assumes that they were stolen, as opposed to having some lawful means to obtain human remains.
Yeah, and I think Officer Gustis's reasoning was that there's no lawful way to obtain bones.
Well, by the time they sought the search warrant, they had reports that he had stolen it. But
Certainly
that
by
it was
that
stolen
time.
from Worcester. So, but I mean,
That's right.
do we have evidence that it was stolen
Well, I think,
before the photograph kicks in?
I think Mr. Medina did tell, I don't think he said that they were stolen exactly, but what he said was, I got them from a guy, I'm not going to tell you who, I paid $3,000 for them. I think with those facts, you can assume that, they were stolen. I don't want to tell the name of the guy. I paid, a lot of money for them. And by the way, how do you get human remains in the first place? I mean, and by the way, this is not proof beyond a reasonable doubt that Mr. Medina committed a crime. It's just this is what the police concluded very, very quickly. And it was the basis for their search warrant, among other facts, but that was certainly what they wanted to present to a magistrate, their belief. And then all of a sudden, in this hearing, we didn't know if it was a crime. We weren't sure, maybe, yeah. I didn't know anything about the statute. Detective Rykowski said, well, we researched all the possible crimes. Well, he didn't have to research it. He just had to read the affidavit of his brother, another detective, Rykowski, who signed this. But this was created with the information that Detective Rykowski provided. So Detective Rykowski can't walk away from his belief that a crime had been committed. In fact, that might even raise another problem with the search warrant. There might be further litigation about that. There may be a Franks problem here, given that there may be an untruthful statement in that.
We've got enough issues to, we've got enough issues to resolve in
I
this
thought
case.
so. It won't be for you. Hopefully, it can be resolved at the trial court stage. But that's another possibility that came out of this hearing.
So without putting words in your mouth, from what I hear from what you said, and correct me if I'm wrong, is that you say we should find that custody commenced after Officer Labby had come in and saw human remains.
After Officer Gustis. Sergeant
Gustis,
LeVay
I'm
came
sorry,
a
right.
little later.
Okay, and so after Officer Gustis saw that, and then you say if we're not persuaded by that, then we should certainly be persuaded that when he learned that he had purchased them for $3,000.
That would be another point in time, yes. I mean, it's a spectrum, right? And you as not just reasonable jurists, but reasonable persons need to decide where that line may fall. So my position is that it happened almost immediately, as soon as Officer Gustis saw these human remains. But then there's more information that comes to his attention, which probably is confirmatory of the fact that there's a crime here. And obviously, Mr. Medina should know if there is a crime there. Mr. Medina, as the recipient of the bones, knows it as well. So everybody knows it. And that's why a reasonable person would not have felt like I could just walk away. I could just send Officer Gustis on his way. In fact, there's no evidence that he attempted to do that. There's a lot of negative evidence that he wasn't arrested, he wasn't handcuffed, he wasn't abused or bullied, that he wasn't told he was under arrest. There's a lot of negative evidence like that. But when you look at the affirmative evidence here, and you put yourself in the shoes of a reasonable person in Mr. Medina's position, you can't come away thinking that you're just going to walk out of this situation. Which is why which at some point may have occurred to Mr. Medina, which is why he complied with all these requests and why he went along with the police to the police station, where they fed him dinner, by the way. They didn't, the Commonwealth makes it sound like they gave him dinner to be nice to him, proof of their good treatment of him. But in fact, it's proof of their continuing control over him. He's not allowed to walk off for the 3 hours that he's waiting for Detective Rykowski to resume his interrogation. He's sitting in an interrogation room, closed off, eating a dinner that was provided to him by the police. So all these facts are affirmative facts that would lead a reasonable person to believe that you just can't walk away from this.
Okay, thank you.
Thank you, Your Honors.